Hello, I'm Victoria Green. I am a senior barrister at 1KBW. Those who don't know me, I specialise in public and private law children cases, many years' experience in both of those fields. This is part of our 1KBW series of Going Beyond the Threshold. I'm sat here with Lucia Crimp. She is going to deal with a topic of looking at the issue of domestic abuse and how that is dealt with in private law and public law cases, and what the contrast is between those two.
Thank you. And yes, of course, domestic abuse is one of the key issues in all types of children proceedings in the family courts and has been the focus of reform in recent years, not least the Domestic Abuse Act 2021, which introduced various changes, including, for example, the statutory definition of domestic abuse, that much broader definition that's now found in Practice Direction 12J, and the prohibition on cross-examination in certain circumstances, including the introduction of the QLR scheme. More recently, we've had, for example, the President issuing new guidance effective from the 12th of January 2026 on non-molestation orders, with the Family Justice Council issuing in tandem best practice guidance and injunctions. So on the one hand, when we're looking at domestic abuse in private and public law, there are universal definitions and a universal focus on best practice. There's been a real shift in how proceedings that involve domestic abuse are conducted, looking back also to, for example, the introduction of FPR Part 3A and the practice direction in respect to provision in relation to participation of vulnerable parties. But perhaps there has been quite a spotlight on private law proceedings and reform in that area after, for example, the Ministry of Justice Harm Report and changes such as the Pathfinder pilot, now called Child Focused Courts, which it was, of course, announced on the 17th of March 26 would be rolled out nationally with funding. So in that context, I want to look at some of the key similarities and differences in the treatment of domestic abuse in public and private law and consider lessons that can be shared. So I suppose looking firstly at differences, clearly these are different types of proceedings with different tests. In care proceedings, it's for the local authority to prove the facts it alleges. The local authority has to evidence threshold. It may be that both parents are disputing those allegations. In contrast, in private law, typically one parent is making allegations against the other. And so there are some key procedural differences and different tests that apply. There's a difference in the way that interim contact is managed where allegations are being made. So in public proceedings, there's an expectation in most cases that contact will be frequent. The burden would be on the local authority to make an application to the court if they wanted to suspend contact, and that's Section 34(4) of the Children Act, of course, and it needs cogent reasons to do so. And in practice, while courts rarely make orders specifying the level of contact, judges frequently do give indications in public proceedings about what they consider to be appropriate contact. So, for example, we have the case of RE-DS, Contact with Children in Care, 2020 EWCA Civ 1031, where it was held that, paragraph 12, a parent applying for contact is entitled to expect that the court will form its own view of what contact is appropriate in all the circumstances, however influential the professional view of the local authority may turn out to be. In contrast, in private law proceedings, of course, contact, including interim contact in domestic abuse related proceedings, is very much within the remit of the court. And where there are allegations of abuse, professional contact is not free or routinely provided through a local authority. Sometimes family and friends need to step in, or ISWs, contact centres. There can be long waiting lists and other limitations. Similarly, in local authority care proceedings, the local authority will often support with, for example, domestic abuse support work programmes. And in private law proceedings, parties at the moment don't have access to those programmes through CAFCAS as they used to. And in terms of those differences, plainly part of the focus of the child-focused model is the idea of creating a more holistic multi-agency approach with the court working with local partners and third sector agencies, etc. And that rollout, of course, as we've talked about, is imminent. But moving on to look at some of the similarities between private and public law proceedings, one of the things that's interesting is the approach taken to the fact-finding exercise itself. And in private law proceedings, much of the focus in the case law is on the fact-finding hearing, whether there should be one, necessity and proportionality of having one, and that exercise in any particular case. I want to talk about a couple of recent decisions that consider the fact-finding process in private law, but which draw an express link with the public law process and how they may or may not differ. The first of those is TRC and NS, a case from 2024, reference to FLR 248. And that's a decision of Mrs. Justice Leven. It was an appeal against a decision of the magistrates to use admissions effectively to arrive at welfare decisions without having a fact find. The appeal was dismissed, and the case was said to reaffirm effectively the importance of judicial discretion in case management decisions. In particular, Mrs. Justice Leven talked about Practice Direction 12J, and the view taken in that case was that Practice 12J was guidance rather than binding, and that it wasn't meant to be a formal tick box exercise. Mr. Justice Leven also made wider comments as to the necessity of fact-finding hearings in private children cases and distinguished them from their public law counterparts, and in particular paragraphs 45 to 47 of that judgment. The case talks about it being a good example of why separate fact finds will often be neither necessary nor indeed helpful in a private law dispute, there being a very strong overlap here between the facts and the welfare analysis of what is in the children's best interests. She said that the holding of separate fact-finding hearings and the concept of findings of fact being binary emerged from public law cases, where, of course, threshold must be crossed before intervention by the public authority is lawful. And then went on in that judgment to say that, in effect, it can be difficult and often unhelpful to try to compartmentalise these matters in private law, and that in many private law cases with allegations of domestic abuse, where the court is actually focusing on the relevance of such allegations to the best interests of the children, it's much less clear, she said, that separating fact-finding from welfare is a helpful way to proceed. She talked about a holistic approach, and that effectively the neat categorisation of truth and untruth in hard binary facts often sits uneasily with the reality of failed relationships. In her words, it may be much more helpful for a court to consider the evidence, including that of the FCA, in a holistic way rather than trying to separate facts from welfare. But interestingly, that element of the decision was not followed by Mr. Justice MacDonald in ER and NT. That was a case from 2025, EWHC 2146, another case in which a father had made a number of admissions. Mr. Justice MacDonald disagreed with that approach entirely, and in fact said, firstly at paragraph 58, that he didn't consider himself to be bound by the decision in respect of Practice Direction 12J, saying that the musings on that were obiter, and that in fact the approach set out in Practice Direction 12J is obligatory. But also that at paragraph 59, he went on to say that insofar as Mrs. Justice Leven had sought to suggest that in TRC and NS, that those paragraphs we've talked about, 45 to 47, that in those paragraphs there was some distinction in the exercise, he said it's not helpful to seek to draw a distinction between the nature of the fact-finding exercise in private law proceedings and that in public law proceedings. The burden of proof in all family proceedings lies on the party seeking to prove the fact asserted, and the applicable standard of proof is the balance of probabilities. And later went on in this paragraph 59, went on to say, in circumstances where the findings of fact made by the court provide the foundation of the welfare evaluation, to conflate fact-finding and welfare evaluation in private law proceedings as elements of a broadly defined holistic process seems to me to risk introducing confusion by depriving the parties of the legal and procedural certainty inherent in the well-established civil law approach of finding the facts, applying the relevant law to the facts found, and thereby arriving at the case-specific answer. And therefore, in effect, didn't agree with that approach, said that wasn't in accordance with previous Court of Appeal authority, and said particularly as to the nature of findings of fact in family proceedings, have borne in mind the decision of the House of Lords in Re B, where a legal rule requires the facts to be proved, a judge must decide whether or not it happened. There is no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. That test we're all very familiar with. So a clear view is expressed in that second case that once you get to the fact-finding exercise itself, there isn't a distinction, Mr. Justice MacDonald says, between the nature of the fact-finding exercise or how those findings are made and or utilised in private law proceedings and public law proceedings.
Yes. So when we're in public law arena, in public law proceedings, and just thinking about obviously the fact-finding element, obviously we're focusing on the domestic abuse issues, but whether that fact-finding element, that process, is there a way, or can it be short-circuited in the public law proceedings?
Yeah, so it's interesting because often in private law cases, what's being talked about is trying to avoid fact-finding hearings, or when they're necessary, when they're not necessary. One interesting comparison is when we look at public law proceedings that conclude without a fully contested hearing or without a fact-finding exercise, or where threshold isn't challenged, parties might make admissions. There was a recent case of Re-D, Threshold Findings and Final Orders at IRH 2025, EWCA Civ 1362, where Lord Justice Cobb looked at this issue. And on that point about admissions being made, was very clear, firstly, paragraph 41, that the obligation is squarely on the court to be satisfied of the threshold criteria. So the court can only make the orders when it's satisfied. Threshold can't be determinatively resolved by agreement between the parties, a fact we're all aware of course. Or on the more specific scenario where parents don't respond to threshold at all. The case also deals with that. Lord Justice Cobb talks about concerns about paragraph 148 of the standard form orders, which provide effectively that if parents fail to comply with their directions for filing responses, they're deemed to accept the threshold allegations made by the local authority. And the Court of Appeal in that case was clear that's not a safe basis on which to proceed, and suggested revised wording at paragraph 148 effectively in terms that if the parents fail to respond to the schedule of findings in support of the threshold criteria, the court may proceed to consider whether the Section 31(2) Children Act threshold criteria are established by reference to the written evidence filed by the local authority, and invited the Standard Orders Group to consider that in the next round of amendments.
Yes, and I think that amended wording is now being inserted to all the new template orders about that. Any other issues that you can see that do particularly arise in public law procedure?
Yes, I suppose one issue is in respect of public law proceedings, you might have a question about whether or not an alleged perpetrator should be involved in proceedings at all. So whether or not that person should have the right to notice of proceedings or the right to party status. And there have been two recent High Court decisions that talk about the illustration of those principles and how they operate in practice, which I think it might be interesting to touch on briefly, because there is on any view a high bar for excluding a parent from the opportunity to participate in court proceedings. And the case law makes very clear that the outcome as to whether or not someone is involved is not to be determined simply by the fact of there having been domestic abuse, but by the court's assessment of effectively whether that risk can be managed and whether or not the procedural controls are in place. So in the case of M and Hounslow London Borough Council and another 2024 EWFC 173, the court in that case refused to dispense with service on a father who had PR, despite there being a history of domestic abuse, based on the risk being an older risk that could be managed. But in contrast, in a mother v. a local authority in another 2024 EWHC 1747, the court did grant an order dispensing with notice to a father who didn't have PR. In that case, the key feature being that there was a genuine and corroborative fear of honour-based abuse from the maternal grandfather, and it was felt that risk couldn't be managed. So that really shows that it is a very fact-specific exercise that's done looking at all of the facts of the case, but also the protection that can be put in place. And perhaps those cases and changes, such as the Pathfinder pilot in private law, have highlighted that in both public and private law proceedings, a key issue for courts is ensuring effective and safe participation of all of the parties involved, including the children.
Thank you. Very much hope that you'll be able to join us again for the next session, and indeed future sessions, which will continue to explore what we hope will be interesting and useful topics, challenging areas of public children law. Thank you.